unlikely to, in a sense, make use of it for a bit. So
I'm grateful.
thank you.
Well, Lord, I was dealing yesterday with the first substantial meeting between the parties in April 2007 where the client's requirements were communicated. And as I explained, really 3 points to be derived. First, Mr. Walia accepted, and my learned friend put it to my own clients, that the client's client requirements were A, capital protection, B, coupon to meet the ABK lending, and C, some return. Second point, the claimants were not challenged on their evidence about their requirements, which the judge ultimately accepted, except to a very limited extent. In particular, whether the word always was said about the coupon meeting the ABK interest, which I submit is a distinction without a difference when a bank is marketing a product. Saying the coupon will meet the ABK interest and the coupon will always meet the ABK interest is hardly going to make a difference to the lay listener. Thirdly, Mr. Walia clearly accepted, and the claimants were not challenged, on their evidence that they wanted no risk. So that was where we got to in April 2007. I'll now go on in the history. The next meeting was on the 22nd of June, but before that there was the provision of some documentation regarding the product, and the claimant suggests that the product documentation made it clear what the product was, and that was in some way overlooked by the judge in this case. But that again is an unfair characterisation of how the evidence went at trial and what material the judge had. The pertinent documentation that went out after the April meeting comprised first an investment proposal and fact sheets that were sent out at the end of April 2007, and you can see those in bundle H1 at tab 111. That's the wrong reference. 110. 110. So this was from Mr.
110.
tab 110.
Yeah.
This was an email from Mr. Sheridan there to Mr. Taha, copied to Mr. Walia. Mr. Taha, thanks for the courtesy extended to Mr. Walia and self during our visit to your office. As discussed, attached, please find the investment proposal for REIT Estate Investment Trust Basket Capital Protect noted with income products. And the subject is called proposal. So they're making a proposal. Over the page, one sees indicative fact sheets. First paragraph, public tariff floor with coupon on the real estate world basket. Global quoted real estate is the best performing asset class over last years, especially REITs are highly attractive as of their liquidity and low correlation to other financial assets. Therefore, we offer a product with the underlying of 3 indices covering Japan and 2 European real estate indices. Now, just pausing there, this is not a point I'm particularly on at the moment, but just to mark it for the future. That is quite plainly a piece of information on the merits of the investment. I'm going to come to this later when we dissect the rules, but what the rules in summary are about is saying you can give information, just neutral information. You can give information even if in your own mind you know it may influence, or you think it may influence the potential investor. But what you can't do is comment on the merits. So in terms of my Lord Sir David Steele's example, you can't say those are good apples, those are delicious apples. You can say there are 15 apples on the tree and they're red. And you might say that knowing the person likes apples. But what you cannot do is comment on the merits. Qualitative, saying things are good or bad, indeed as my Lord Sir Richard Field identified. So, but anyway, I'm going out of my way, but that is an example of information on the merits. And going down the page on this first page, one sees in the one sees a capital guarantee 100%, coupon 10% annual payment. So again, the lay reader is seeing, as our clients would see, 100% capital guarantee and 10% annual payment. And I should say that this fact sheet is intended to be a user-friendly document. This is the only document the client's got which was intended to be a guide that they might be able to understand. But even here, the readily explicable bit, which says capital guarantee and coupon, just says 100% capital guarantee and 10% coupon. Now, it's right to say, as the friend relies on, that a bit lower down, you get this rather Delphic material which says structure, min redemption, coupon PA, total floor, participation, but that's not explained. And equally, what's below it is a calculation that's there, not explained. Now, the lay reader might want an explanation of what that bottom part means, and in fact, after the next 3 pages, which describe the underlying assets, which I don't need to take time on, one gets an example of how it actually works. This was pages 6 and 7, which when my learned friend was going through the document, I asked him to take you to, and he didn't want to. And there's a reason he didn't want to, because it entirely bears out our case. If one looks at investment into Sarafloor real estate basket over the last 3 years on page 6, one sees assumption, this is first without leverage. Assumption, participation 90%, your assets, your investments 30 million, performance of underlying investments 91%. Then you have a formula, redemption at expiration. Step 1 formula, minimum redemption plus nominal half coupon times participation times max expiration minus strike plus coupon. And that is then given a worked example below, and the sum is 30 million. This is what you're getting at expiration. Redemption at expiration, you get your 30 million back, plus you get your coupon, plus you get whatever your performance is on the product. So this equation said
not actually following the equation. Step 2 we're looking at, are we?
Yes.
Step 2, US dollars 30 million. That's the investment.
That's the investment. So the first thing you get
plus,
and then there's a
25.5 million.
Yes.
What times?
Well, I don't pretend to understand, and none of the witnesses could understand what the performance.
So what is the 25.5?
Well, one doesn't.
That's the 90. That is the performance at 91%.
It's the performance. It is what one knows. It is their representation of the performance element.
I.e., that what the market would move sufficiently in their favour to give a profit of 25.5 million, or what?
Well, yeah.
You think that's what it is?
That's what it's saying. I mean, it's as it happens. This equation is in fact gone.
Then you have star 0.9, star 19% minus 100%.
So that's trying to.
Maybe that's the 91%.
Yeah.
Plus coupon.
Exactly.
Yeah.
So what one gets is capital back, the 30 million. You get a rather complicated and in fact probably inexplicable performance calculation on top, plus
the
coupon.
Yeah.
And then you end up with this rather fabulous 59 million at the end. So there's no doubt in their own, the only explicable, or intended to be explicable document, they are being told capital plus performance plus coupon. Then there's the next page.
Yeah.
Yes. Just to be clear, the 9 million of the sum at the bottom is indeed the coupon, because that's 10% over 3 years. So 30 million, so what you end up with 30 million capital plus this strange performance figure plus the coupon. You get the same thing over the page, and this is the example with leverage. And again, just flagging forward to a point we get later, just to note that with leverage, what's being said here is that instead of just having the loans from ABK, which are used to buy the investment, one could borrow more from Saracen and buy even more investments. That's what leverage is. This comes to a point where learned friend was suggesting that Judge somehow didn't understand there was originally leverage. That's a totally bad point. Everyone knew, and the whole case proceeded on the basis the initial investments were funded by borrowing from ABK, but there was questions of leveraging or further leveraging when those investments were then subject to further borrowing from Bank Saracen, which would fund a new wave of investments and be secured on all the investments. So that's what they mean by with leverage. And you get exactly the same formula and exactly the same step 2. So you get your 60 million, you get your capital back, plus you get your funny performance calculation, whatever it is, plus you get your coupon. Now this document obviously followed the April meeting, and one can readily see that it reflects what the claimants were told at the meeting. And Mr. Alia, at cross-examination, couldn't explain the equations at all. And in fact, in relation to this document generally, his evidence was that you would need an additional, you might need an additional layer of advice to understand it. And the judge recorded that at paragraph 80. And it took later more knowledgeable witnesses, and in particular the Swiss bankers, to confirm that the equations on page 6 and 7 are completely wrong, don't describe the product, and indeed I think Dr. Fitzgerald's description was nonsensical. And what's quite surprising is that even now, up till today, there hasn't been any acceptance from a learned friend, Mr. Brindle's client, that his own literature did thoroughly misdescribe this product. They've even, on this appeal, put in a skeleton saying the product was fairly described in the documentation, including this fact sheet.
You cross-referred to evidence from a Swiss witness and from an expert relating to
yes.
This.
I think
I'm not asking you to look it up. Could you just give me the cross-reference?
I can, but I'm afraid I think I've got it later in my notes. Can I make a note and make sure I've given it to
Would
you?
Do that? Thank you very
by
much.
the time we get to the end of the day. Now, so that's that document, that set of documents. That's all they had at this stage. Then there's another set of documents set out on the 5th of May, and you see that at tab 113. And this included the process flow you've seen. This set of documents also included another iteration of the same fact sheet, the same user-friendly document. And that's at page 6325 in the bundle. It's quite near the back of the clip. It starts on page 6325. And it's really a restatement of the same fact sheet. And it has the same formula, this time at the last page of the clip. So the same error is repeated.
This is what's called a term sheet.
Sorry, this is still called indicative fact sheet. It's at 6325 it starts. It's really the same.
So I was looking at the introductory email.
Oh, sorry.
Please find the following. Which of those four
It's
items?
the detailed investment proposal.
Detailed investment proposal.
And I obviously rely on the fact that this is an investment proposal.
Right.
And the document starts at 6325.
The term sheet is the one at 631.
Yes, I'm going to come to the
Yeah,
term sheet.
just.
Yes, thank you. So the
Sorry,
user-
you're on 6325.
6325. I'm not going to go through it again. It's,
Yeah,
I think it's
you
like
say
it's
it's much
the
the
same
same.
or a reiteration. I think it's a reiteration.
Yeah.
And it's got the same problem and the same representation about getting your coupon back and your performance and your capital at maturity. Now, it's right to say that there's also the term sheets produced in this clip. And they start on page 359. Now, these are much less user-friendly documents. They're very difficult documents to understand.
6.3.
Starts at 6319, the term
Okay.
sheet. And one might expect, the user might expect it to reflect the more user-friendly version in the fact sheet. Just one point to note at the top of page 6319, coupon is in fact referred simultaneously. See the top paragraph, it says simultaneously being able to protect the investor capital of a nominal amount and pay a temporary interest. Just again flagging forward to a point that comes up later, this term sheet envisages interest as interest and says so. But it's right to say that the product, in terms of the equation, is accurately described in the term sheet. It is a difficult to understand document, but if you go over the page on 6320, the formula given there is in fact accurate. The N times CP times P over X formula.
And I'll take your word for it.
Well, that's exactly the point. As the judge noted at paragraph 83 of his judgment, this whole document is not easy for a financially inexperienced reader to understand. And that's why one had the fact sheets, which were supposed to be the user-friendly documents. And I'm obviously not going to go, I haven't got time to go to all the iterations of the term sheets and so on. It's right to say there are lots more term sheets produced over time. They're all, none of them are any more user-friendly than this one. But there is never a revised fact sheet or investment proposal which corrects the error.
And by error, you mean in the formula?
Yes, and the representation, when in describing the working of the product, that you get your capital at maturity plus performance plus coupon. So that's the documentation before the next meeting, which was on the 22nd of June. Now, in relation to the 22nd of June meeting, the judge accepted the evidence of Mr. Khorafi and Mr. Noor that the statements made in the April meeting were repeated at the June meeting. That's at paragraph 199 of the judgment. And that was also fully justified by the evidence. Mr. Noor gave clear evidence at paragraph 30 of his witness statement, which the judge summarised at paragraph 193. The judge recorded that that was not challenged. And he's right about that. I actually showed my lords the relevant part of the transcript yesterday, so I wouldn't have to take up time again, but just for your note, it was at page 81 of the... Sorry, it was at D1, tab 53, internal page 81.
Now, this is the meeting Mr. Taha did not attend.
My lord, yes, and I'm about to come to that, exactly.
Oh, sorry.
That's exactly right. So Mr. Noor gave evidence that wasn't challenged. Mr. Walia let himself down in relation to his evidence at the meeting by saying in terms in his witness statement and in cross-examination that Mr. Taha was there. Now, contrary to the learned friend's submissions, in his submission, Mr. Walia's oral evidence was wholly unsatisfactory on this point. The cross-examination is at D2, tab 56, page 30 to 34. Now, Mr. Walia starts at the bottom of page 29 saying he doesn't remember. But the problem with that is his witness statement says he wasn't there. And as I explained in the documents, which I went through between page 30, 31 and 32, the documents show pretty clearly that Mr. Taha wasn't there, which is why I then said, you now accept, this is at the bottom of page 32, question, you now accept he may not have been at the meeting. Answer, like I said, he attended one of the meetings. Then I put to him paragraph 117 of his witness statement, and Mr. Walia then suggested something about a diary which had never been disclosed, and then I said, no documentary evidence you produced suggests Mr. Taha was there, simply wrong in your witness statement. He then says, no, my witness statement is correct, but I do not have a document to show he was there. So this is a witness who's already said he doesn't remember. Mr. Taha was there at one meeting. Then, taken to his witness statement, rather than saying, well, my witness statement over-egged it, I can't remember, he was certainly at a meeting, but it may not have been that one, he sticks to his witness statement. So it's inconsistent with his own explanation. And that was then exploded on the next page, because at page 34, at the top, I say, can I just come back very briefly to answer you just given out Mr. Taha's attendance? You do say paragraph 136, Mr. Taha attended the meeting. Was that on the 11th of July? Is that the one meeting Mr. Taha attended? And then he says, correct. So he accepts that the one meeting Mr. Taha was there was a different meeting. And it's an instance that shows quite how impossible Mr. Walia was as a witness. He would change his mind, say things were true when it was clear on the evidence and indeed his own answers that they weren't true, and he was speculating. And he wasn't, as the learned judge ultimately concluded, trying to assist the court. And the judge got this spot on in his judgment, and my learned friend's criticism of the judge's conclusion on this is quite unfair. So going back to the meeting, in a nutshell, the statements made at the meeting were the same as the ones before, and given that the evidence and cross-examination strongly justified the conclusions at the previous meeting, it wasn't difficult for the judge to accept the same things were said at the next meeting, and in any event, this was confirmed by Mr. Nur, and he wasn't properly cross-examined on it. Now, my learned friend submitted in relation to this meeting that the judge just had a process of looking at the claimant's evidence, looking at Walia, rejecting Walia, and finding in favour of the claimants. But that's not a fair characterisation of the judge's actual process, and it ignores the evidence that was unchallenged, and it ignores the fact that this follows what had gone before. Now, in relation to this meeting, my learned friend went to some documents which he suggested were particularly significant beforehand, and my Lord Sir Richard Field asked him whether the contemporaneous documents were put to the witnesses in cross-examination, and the answer is yes, of course. My learned friend's documents were put to the witnesses, and this is a case where Howson and Nicolaisen applies. Now,
I mean, you say that, I'm anxious not to get bogged down in too much detail, but you've been showing us the investment proposals in April and in May, and the term sheets, which led up to the June meeting.
Yes.
I assume that it was at least part of the first defendant's case that those documents in some way revealed the true position,
yes,
i.e. inconsistent with the alleged request for the form of this investment. So those documents were put to them on that basis.
Yes.
Do we need to see that, or
Well,
I'm rather in your hands?
Well, I'm not sure you do. You
Right.
can take it from me.
No,
They were
I'm not pressing
put
you.
to them. I mean, I didn't. There's no, I'm grateful for it. There's no dispute about that. They were. I'm not suggesting they weren't.
They were put,
Yes.
and we don't need to see what response there was to it. No.
No,
And that's fine. I mean, the judge
considered
doesn't
it.
specific. I mean, he refers in some detail to the where the cross-examination took place,
Yes.
in terms of the bundle and the transcript.
Yeah, you will
And
see.
if necessary, we can look that up.
Yes, I think the judge does them accurately, so I
Right.
think you can look that up.
Thank
We could do a check on that, but I wasn't
No,
proposing
that's
to.
fine.
Just on that meeting, can I just deal with one separate point which arises because this is the chronological time for it, and it relates to this leveraging. Now, I've already mentioned this. The leveraging was something that happened with the second wave of investments, which comes later. And as I've said, it is true that for the first wave of investments, the claimants arrived on the basis they were trying to get borrowing. Leveraging was what was proposed for a second wave with new borrowing for new investments secured on both the new wave and the old wave of investments. Now, my learned friend suggests that the judge was unfair on Mr. Walia when he was asked about leveraging, because the judge had misunderstood what leveraging was and had forgotten that the first wave of investments came with borrowing. Now that again is an unfair characterisation of the way the debate ran. Everyone at trial talked about leveraging as being the second wave of investments. You can see an example. I'll just give it to for your reference, or you can turn it up if you want, at Mr. Brindle's own closing skeleton for trial, at bundle C1, tab 28, paragraph 40. The issue in relation to leveraging, and it was by no means one of the biggest issues, it was quite a small issue. The issue was whose idea it was to have this second wave of leveraging, so these leveraged investments with borrowing from Bank Saracen. The claimants said, we said, the idea came from the Saracen side. The defendant said it came from the claimants at this 22nd of June meeting. And I cross-examined Mr. Walia in relation to that, and in relation to his evidence at paragraph 120 of his witness statement, that this second wave leveraging was an idea of the claimants at the June meeting. And I started with the document I've just shown my lord, which was the fact sheet, which itself referred to leveraging at the last page. And it was in relation to that Mr. Walia was giving thoroughly evasive evidence, and the document is at bundle D2, sorry, the transcript, bundle D2, tab 55, page 109. And I'm not going to take you to read all the way through it now, because I think you've already seen it once before, but the passage runs from page 109 to page 113. And what happens in this section of transcript is Mr. Walia does give thoroughly evasive evidence, because it's quite clear from my questions that what I'm getting at is the idea that the leveraging with Bank Saracen was a suggestion from the defendant side at the outset, because it was clear from their very first investment proposal. And Mr. Walia was giving evasive answers by saying there was already leveraging in terms of the ABK lending, which of course didn't help him at all, because we were talking about the leveraging from Bank Saracen and his own evidence and the issue in the case about that being the claimant's idea and not the defendant's, and about it being suggested at the June meeting. And so this ended up with an intervention from the judge at paragraph 11. I've lost the intervention now.
113.
113.
It's your question at page 114
and
line
116,
6, which seems to me to identify
yes.
the different ways in which the word leverage was being used, and the witness agreed with your categorization that you have the first wave of investments, which was based on borrowed money, and then you create another loan, and then up with 3 million new assets, so you end up with 60 million. That's what's being proposed. Correct.
Yeah.
That's the further leveraging.
Yeah.
I think we looked at this.
Exactly. And the judge's interventions then at page 110
Yes, I see that.
are in fact entirely fair. Because everyone knew what we were talking about, including Mr. Walia, and his suggestion that there was leveraging in the ABK lending is just a red herring, as he knew. And it's interesting to see that red herring is in fact recycled before my lords by my learned friend by saying leveraging was always there from the outset. Everyone knew what the issue in the case was, which is the further leveraging, but the leveraging of Bank Saracen, which Mr. Walia was being evasive about. So anyway, that was the June meeting. Now, immediately after that meeting, we have the first wave of investments being purchased. And that wave of investments didn't remotely correspond to the claimant's requirements and were not suitable for them. It's summarised at paragraphs 299 and 300 of a judgment. And in a nutshell, they didn't provide 100% capital guarantee and income stream to service the loan. There was nothing like a guarantee that the capital would be protected and available to pay the principal, and that would only happen if there was...
Where are you referring to?
I'm summarising 299 and 300,
Oh, I see, yeah.
299 and 300 of a judgment. So didn't provide 100% capital protection and income stream to service the loan. Nothing like a guarantee that capital would be protected and available to pay the principal on maturity, and that would only happen if there was, in fact, very substantial growth in the portfolio. And it's something like 17% steady growth in the portfolio to enable that to happen. So absent that, you'd get a potentially huge capital shortfall. And the judge also summarised in his judgment the risks in relation to the product which were identified by Mr. Walford, and that's at judgment paragraph 352. And the judge...
What was the return that you say was needed in order to...
It's 17, approximately 17% per annum.
Yeah.
352.
352. And so the risks that Dr. Walford identified were, and it's worth reading all of those, these are pretty serious set of risks. Now, in relation to the margin call risks, that's a particular problem for the second set of investments. In fact, theoretically, it was also a problem for the first wave of investments, but it's particularly acute for the second wave of investments. The reason it's theoretically a problem for the first wave of investments is slightly technical. It is that the first wave of investments were covered by the IPO in favour of ABK. Now, Saracen seems to have taken a slightly schizophrenic approach in the event to its margin calculation of margin and collateral. What it later does is considers that any commitment under an IPO to ABK is itself subject to margin calculation. It just counts as a liability that's subject to margin. Now, the evidence doesn't show, because we don't have the disclosure, what approach they took to the first wave and whether they deployed that approach at the time. They may have done, they may not, but they clearly considered they were entitled to. Had they done that, one could even have had margin calls in relation to the first wave. So in fact, although it's perhaps a little bit theoretical because the problem is really acute for the second wave, there was always this margin call risk. And so Dr. Walford identifies all these risks at paragraph 352. He then, as at 353, explains these risks, far from obvious, need to be identified and explained by an advisor acting with reasonable skill and care. He explained it would be necessary to achieve very advantageous returns from the market in order to meet the financing costs alone. He concluded the structured advisor was doomed to failure and was likely to lead to losses even in normal market conditions, in that there was a serious risk the structure would require further substantial margin payments before maturity. In his view, margin was likely to be called from a very early stage. Judge Ben records, said on behalf of the claimants that Dr. Walford is correct to conclude the claimants not given sufficient warnings of the level of risk involved in the investments, a sufficient explanation of the level of risk involved in leveraging their position in order to make the investments and the consequences of doing so in the event of a fall in the investments, a sufficient explanation of the risk of margin calls being made and the consequences of such calls, or an adequate explanation of the nature and effect of the documents which they signed relating to the investments. I accept those submissions.
So that acceptance of the complaint that there was no adequate warnings, that's based upon what the absent the warning, then they wouldn't understand what was going on, rather than there was some positive obligation to make the warnings. Is that?
Well, in 353, Dr. Walford's view, as recorded by a judge, is the risk needed to be identified. In this kind of selling this kind of product to the consumer, these were far from obvious risks that needed to be identified, and they needed to be identified very clearly. And they simply weren't, and the judge accepted that.
Okay.
And the last point to remember in terms of what's inappropriate about this first wave of investments is the claimants had said they wanted no risk. And that is the one point it's impossible for my learned friend to challenge that finding on the evidence. It was quite clearly accepted unequivocally by Mr. Alia and was unchallenged in the claimant's evidence.
Were they told that there was an issue of risk?
Well, I think that's the one thing Mr. Alia says they were told of issue of risk. Yes, but Rabo, of course, is AAA rated. Yes, and yes, my junior reminds me, one of the ways in which this product was marketed was it was backed by Rabobank. I may need to come back with some specific references on that to make sure I'm giving accurate submissions. But this product was sold on the basis it was these are rated investments. Now, I've just referred to the margin call risk, and I've explained that theoretically arose even in relation to the first wave of investments. What's important to note both for the first wave and the second wave is that there is an immediate potential margin call risk even on day one of the investments. And it's quite a simple point. The potential liability is essentially for 100%. The notes are bought at a profit to the Saracen side, so the immediate market value in the book, in the custody accounts of the notes, is less than the amount of the liability. Even without a haircut, that gives rise to a potential margin exposure, depending on whether Saracen want to call it. And they did apply a haircut. Appears to have been about a 5% haircut, although it's not clear. So there was an immediate margin call exposure, and that gets particularly acute in the second wave, which I'll come to. So those were the judge's conclusions on suitability and disclosure of risk. There is then the second wave of investment, which I'll come to now, and the judgment records at paragraph 113 that Mr. Nair sent out proposals for leveraging, and that is the lending from banks.
Paragraph 1?
Paragraph 113, I hope that's the correct reference.
Yeah. Okay.
now on the 3rd of July.
Exactly, we're into July.
Yeah.
So Mr. Nair sent out proposals for leveraging, and as the judge recalls, documents projected a substantial surplus being derived. That then leads to the next meeting on the 11th of July, and at paragraph 116, the judge accepted that Mr. Wali has stated that the product would enable them to repay the interest and give them income and pay the loans on maturity. And the judge summarised the rival evidence about this in the cross-examination at paragraphs 200 to 206. And there was, in truth, a stark conflict of evidence, and the judge heard the evidence. Everyone was cross-examined, and the judge was entitled to prefer the claimant's version of events as he did. Mr. Walia did accept, although there was quite a bit he didn't accept, what he did accept was that he did not discuss the risks associated with the leveraging. And that's, for your my Lord's reference, is at D2, tab 56, internal page 111. And that's quite a significant point, because these leveraged investments were, if anything, even more dramatically unsuitable than the first wave, and that's for 3 reasons. First, there was an enhanced margin call risk. There was lending, 100% lending from Saracen to match the new investments, and that lending was collateralised on the instruments only.
Sorry, I'll say that point again.
Yes. Enhanced margin call risk because there's 100% lending from Bank Saracen to match the new investments, which is collateralised only on the instruments. So there's an immediate exposure to a margin shortfall. And just, again, for my Lord's note, we've produced an Appendix 2 to our closing, which needs a bit of a cold towel, but it does explain how margin could have been called and how on day one the collateral value was exceeded by the lending, even before you apply a haircut. So there could have been an immediate margin call. And obviously any drop in the value of the investments whatsoever would have meant more and greater margin calls.
Were these marked to market on a daily basis, or what?
Well, I don't think the evidence shows that. I imagine they would have been. I think that's pretty likely. A learned friend doubts it, but there's an underlying basket of traded instruments. I would expect they would have been. My learned friend isn't sure, but certainly. Well, I don't. Yes, I mean certainly regularly and frequently, whether daily, I don't think we know. And if margin call is not met, the whole structure is vulnerable because the whole structure depends on keeping the products going to maturity, and you don't get any income or capital protection at all if you don't meet a margin call. And not only do you need this constant 17%, this 17% annual growth I've referred to, you need that constantly. Because of the marking to market, any fluctuation yields a shortfall for collateral. So those are the margin call risks that Dr. Walford was referring to in the passage I've just taken you to. And given that Mr. Walia accepted that the claimants wanted no risk, it's startling that he did not disclose, as he accepted, the risks associated with this leveraging. Now, in relation to the second wave, the other particularly disturbing point about this wave is that they put the claimants and Bank Saracen in immediate breach of their obligations to ABK. And that is because the commitment in relation to the first tranche by the second claimant and the Saracen was to pay all coupons and principal to ABK. That was a legal binding commitment. But as part of a leveraging, Bank Saracen insisted on taking security over those investments, which was obviously in breach of the commitment. And that's dealt with in the judgment at paragraph 125. Yes, the IPO actually specified no lien, I should be reminded. And what then happens, that had to be resolved of ABK, which is quite a tortuous process. We don't need to go to all the documents, but there's a lot of documents in the trial bundles, some of which are in these bundles, explaining how there was a long fallout with ABK, and the problem had to be resolved. And it was ultimately resolved, my learned friend pointed out, by 20 million being paid to ABK. He didn't spell out who by. 20 million was paid by the claimants to ABK to resolve the problem that arose because of Bank Saracen putting them in breach of their commitment to ABK with the second wave.
And that was paid by way of security, not a prepayment on the loan.
It was paid. It was paid cash and credited as a debited, I should say, to the second claimant's account with Bank Saracen. So it just piled on. So it piled on to the lending that Bank Saracen was giving the second claimant, and that 20 million then got calculated for collateral, including the collateral margin calls that later
added to the loan.
Added to the loan and was used in the collateral calculation, which later, and you ended up with the margin calls that made the house of cards fall down. And it's easy in a case of this kind to lose sight of the numbers, but this was a 20 million breach of obligation that this second wave put the second claimant into. Now, the judge pointed out some of the features of the notes at paragraph 49 of his judgment. Just for my Lord's note, 49 has a number of sub-paragraphs. In relation to his little 6, one needs to keep in mind, as the judge did, because he picked the point up later, that little 6 needs to embrace the point already made at paragraph 125 of the judgment, which is there's a breach of the IPO. The judge also provided a summary of why this second wave of investments was unsuitable at paragraph 302 of his judgment. No, 301 of his judgment. And again, one needs to read that also with his later findings about the risks and non-disclosure, which he makes at paragraphs 352, 353 and 354, which I've just taken you to. And 355. Now, those are obviously the biggest problems which I've just identified, but there are in fact a number of other disturbing features about this wave of investments. For example, and there's quite a lot of evidence at trial about this, the transactions were purchased prior to confirmations being received. That's one point. Another point is there was crucial information missing on the term sheets. And the underlying investments that were later supplied, which the final term sheet didn't come out till October, so many months later, weren't even the same investments. So one signed up for a particular basket of underlying shares. The ones that Saracen decided to put in were different shares. I'm going to come to a particular point on that in relation to one of the criticisms that my learned friend makes of the judge. But it's another measure of quite how dysfunctional all these arrangements were.
And this was an example where even the issuer was not identified.
This was an example where the issuer wasn't. Yes, one of the problems with the issuer wasn't identified. That was a problem, particularly when one is concerned about the rating and issuer risk. If you don't know who the issuer is, you can't assess the issuer risk. And if you think you signed up to one basket of shares, it's a bit surprising, given that the performance is calculated on the performance of the shares. It's a bit surprising if Saracen decides to put in some different shares. So these are obviously all the sorts of points that the judge had well in mind, and it's another indicator here about the immersion factor. This judge, hearing this case, was alive to all of these points, which he took into account in deciding these investments were unsuitable and these risks were not fairly disclosed. And what this process is in front of my lords is consisted by learned friends doing a slightly optimistic reading of part of the judgment, suggesting that represents the totality of what the judge considered, and suggesting it's somehow to be criticised. But the reality is that the evidence fully justified all the findings made by the judge, and the judge was immersed in the evidence, and he had all of this detail. Can I now go to the third wave of investments? And just to summarise the failings in respect to the third wave, they're picked up in the judgment at paragraph 302. And essentially, what the judge is saying is you've got the problems he's already identified with the previous wave, and then to an even greater degree, you've got a problem with the third wave, because you've got this cross-collateralisation scenario where all the potential problems of the second wave are visited on the third claimant as well. So if there's a problem with the second wave investments, because of the cross-collateralisation, she gets it too. And no suggestion that that was ever explained to the third claimant. They never even met her. And never established her attitude to risk. And just again for my Lord's reference, we've summarised the failings in our skeleton at paragraphs 179 and 194.3. So we say that it's hardly surprising that the judge, looking at all this material, reached the conclusions he did about suitability and about the claimant's breaches of their contractual obligations, and to suggest he didn't have the material for it entirely underplays the evidence. And as I say, I've only given you a whistle-stop tour of some of the more significant areas. There was much more in the cross-examination, much more in the documents, and the judge was immersed in all the detail. So, my Lord, against that background, could I go to Mr. Brindle's appeal on this part of the case, starting with his ground one? And my learned friend starts off, both in his oral submissions and in paragraph 38 of his skeleton, with an unfair characterisation of the judge's process. As we've seen, the conclusions the judge reached were in fact consistent with Mr. Walia's own evidence. They were supported by fact sheets, which were the defendant's only document intended to be and potentially intelligible to a layman, and they were consistent with unchallenged evidence from the claimant's own witnesses. The findings did give effect, in my submission, to the inherent probabilities, and the judge's approach was a model approach in my submission in terms of reaching a judgment on the facts. My learned friend makes a point about the judge not fairly distinguishing between, or unfairly distinguishing between recollection and speculation. Now that doesn't wash in my submission. Mr. Walia was transparently and repeatedly making things up. He was giving positive assertions, both in his witness statement and in his oral evidence, when he was subsequently forced to accept that he did not know and had no basis for his speculation. Now, my learned friend is quite right to say in some cases, when one's dealing with events long ago, there's a process of reconstruction. That's right. But this isn't a case of a witness being a bit woolly about events that happened a long time ago and he can't quite remember, and having to do a bit of reconstruction. This was genuine, full-blown speculation, in that Mr. Walia was asserting things when he never had any basis for the assertion. He was asserting things about things someone else might have done that he simply didn't know. And he was asserting it as if it was a statement of positive truth. Now, my learned friend also in his skeleton, and I think, in fairness to him, less so in his oral submissions, his skeleton's at paragraph 41, makes a rather sweeping point to the effect that the judge based himself on the proposition that contemporaneous documentation was all false or unreliable or backdated. That's completely unfair. To a very limited extent, the judge did find some documents were false and backdated, and indeed they were, and I'll come to that in the next section dealing with the client's point. But that's all an Aunt Sally, because the judge's findings on suitability and breach of contract were nothing to do with false documents. The conclusion he reached at the meeting were not based on anything to do with false documents. And I'll come to this perhaps at the end of this part of my submissions, but the bottom line is that there were no documents of such significance or so compelling as to require a judge to ignore the defendant's own admissions or to gainsay the evidence given by the claimants, some of which wasn't challenged and which was supported by other parts of the documents. And I'll make a submission in relation to that at the end. One then has my learned friend's tactic, which is to make a series of criticisms of the judge, rather than focusing on the evidence the judge actually relied on. My learned friend makes more generalised criticisms of a judge, and with one exception, which I'll come to, none of my learned friend's criticisms of a judge's approach go to the findings that the claimants are actually challenging. One needs to bear in mind the claimant's target here is ground 1.1 of his skeleton and his notice of appeal, and that is the judge's findings on the claimant's requirements and what they wanted and what they were promised. And so one needs to remember, when looking at my learned friend's various criticisms of how the judge approached the evidence and what he said to Mr. Alia and so on, but none of it goes to this part of the case, with the one exception I'll come to. The other point to bear in mind when looking at what my learned friend says about the judge's treatment of Mr. Alia is that where he ends up isn't particularly different from where the judge ended up at paragraph 166 of his judgment. On Sunday, so that's 166. Reason I explained his attempts to evade and prevaricate, together with his inability to distinguish between matters within his own knowledge, matters of which he had been informed by Mr. Nail-Rubbers, and matters of which he had no knowledge, but in respect of which he was ready to speculate what might have happened, led me to conclude he had no interest in assisting the court in his task of ascertaining the true facts in this case. Now, on Sunday, my learned friend, putting things as diplomatically as he could, obviously for his own client, accepted that Mr. Alia had weaknesses and that he gave quick answers and backtracked and that he speculated. But this is exactly what the judge is saying. It made him a thoroughly unreliable witness, and he was not trying to assist the court because he gave quick answers which were factually wrong and untrue and on which he would backtrack, and he gave answers that pretended to be statements of truth when it turned out he was speculating. And it did make him a thoroughly unreliable witness, because his answers could never be relied on, and if you had the material to probe, as we quite often did, the answers would change. And if you didn't have the material to probe, you just didn't know if you could possibly rely on any answer that he gave. And that's in substance what the court has held. Now, the court did hold he had no interest in assisting the court. That's a perfectly fair conclusion on the evidence, and that is classically a matter for the trial judge to assess. And against that background, I'm going to come to my learned friend's examples. I'm only going to go to the ones my learned friend took orally. Time doesn't permit me to go to the ones which are in his skeleton and which he didn't think were big enough points to take my lord's to, so I'm not going to take my lord's tips to them either. Starting at bundle D2, tab 55. Sorry. I haven't got the reference. Sorry, I apologise, my lord. I've not got the page reference.
No
44.1 of my learned friend's skeleton. And you can see from there, it's page 12 of the transcript at 55.
Sorry, where are you wanting us to go?
Yes, sorry. So the criticism made, and repeated orally, was at 4.1 of my learned friend's skeleton, and it's a reference to D2, tab 55, page 12.
Thank you.
And the criticism is of the passage where the judge says, I'm not going to be assisted by the client arguing his case in the witness box, which is a perfectly fair intervention. And it's indeed a criticism of my cross-examination. The judge says, if what you're asking about agrees with what regulation requires, if I may say the way to do it is put the regulator to him to see it, and then find out what he actually did, and then no doubt I'll hear where he did mess up with regulation. And then his lordship, what's dangerous happening is that this witness has been now there as a partial owner of this defendant, he's going to start arguing his case in the witness box, which is not really very helpful. Now the background to this, and my lords can read it on page 10 and 11 of the transcript, is that Mr. Walia had been arguing his case. Now, obviously, to some extent, there's a criticism of me because I was inviting him to go to the rules and perhaps, in a sense, inviting him to argue his case. But the judge's point that Mr. Walia would be arguing his case and he has a financial interest is not particularly surprising because this followed shortly after what was a very big bombshell at the beginning of the cross-examination, where Mr. Walia accepted that he was essentially had a 40% interest in the company. Now, my learned friend sought to suggest this was in some way common knowledge and not particularly startling. It was not common knowledge. I had a hunch, and I put it to Mr. Walia at the beginning of the cross-examination as a punt, which turned out to be true. And it's worth picking up.
He's a shareholder of Alpen.
Yes, he is the shareholder of Alpen.
Sorry, the only shareholder.
As I understand it. I'd be corrected if I'm wrong. As I understand it.
Alpen is a DIFC company, is that right?
I think it's a Jersey company, but
It's a Jersey company. Yeah, I made that mistake before. Well, there'll be a register in Jersey. Would that reveal that he?
no, I don't think he's a direct shareholder.
He's not a director.
No, that's as far as again, I'll be corrected. I don't think he's a direct shareholder. Well,
He didn't sign the joint venture agreement, did he? Don't think.
I can't recall. I will ask my Julia to check that. And the way this comes about, of course, is the judge, as a trial judge, would have gone into this witness testimony, having read Mr. Walia's evidence, which is at bundle E2. E2, tab 70.
I'm getting fitter as I go.
I'm sorry, and also I must try and remember to ask you to put bundles away, because I'm sure it's getting
E2,
E2,
70.
tab 70.
Yeah. Mr. Shatty's statement.
No, should be, sorry, 71. Should be Mr. Walia's statement. My mistake. 71.
Yeah.
So the judge would have gone into this reading, having read this probably. So paragraph 1, I am the Executive Vice Chairman and Chief Executive Officer of Bank Sarasin-Alpen, the first defendant. There's then, starting at paragraph 8, a long section about his background and career history, which goes on all the way 8 through to 14 and 15, where he says in 15, I was appointed Managing Director and Chief Executive Officer of Sarasin-Alpen. March 8, I was appointed Executive Vice Chairman, also Executive Vice Chairman and Chief Executive Officer of Alpen Capital, and all these other companies. And then at 16, he deals with the incorporation of Sarasin-Alpen. So it's no accident. He has gone out of his way to tell the court all about his involvement, his background and his history, his role at Sarasin-Alpen and all its subsidiaries. But he has omitted to mention, obviously deliberately, his financial interest in the company.
I'm sorry to rise just to one point of detail. Mr. Walia was the signatory on behalf of Alpen Capital of the shareholders' agreement with Bank Saracen.
Thank you. I've forgotten that.
Which the reference is...
Why I asked the question.
Yes, I know, but also trying to answer it.
Yeah.
It's tab 102 of bundle H1, page 6218.
Thank you.
I'm grateful. Now, my learned friend says that the financial interest of Mr. Walia wouldn't be particularly relevant, and why should he mention it? That's, in my submission, another point that doesn't really wash. This was obviously highly relevant. This company, Sarasin-Alpen, has gone out of business and been closed down on the back of this judgment. That is why we're in a difficult position in this appeal, in that I not only need to win this appeal against the first defendant, in commercial real terms, I need to win this appeal against the second defendant, because they're the only ones with the money. And it was obviously relevant, and that makes the judge's comment not particularly surprising, because he would have got a very different impression when he read the witness statement, and it would have been indeed, as I say, a bombshell when it was dropped. Now, the next example from my learned friend was in the same transcript, so we're going to stay in D2 for a while, and it's on at page 18.
So divide 50.
So yes, it's still tab 55. We'll be staying in this tab for quite a while. It's internal page 18.
Thank you.
And again, this is a passage of transcript which starts at the bottom of page 17, and my lords again will perhaps need to read it when preparing the judgment in their own time. It goes on from the bottom of 17 all the way through to 18, and the context of was that I was asking him repeatedly, and having to ask repeatedly, was it that it's right that D1 had advertised itself as being ultimately part-owned by Rabobank as part of the promotional puff. That was obviously correct, and indeed later in my submissions we'll see an example of a document that shows that. And there was an evasive answer at line 17 onwards.
Yeah.
It's just not answering the question. And the learned judge is absolutely right to intervene and to ask him to answer the question. Next example from my learned friend, page 22 to 3, and I'm not sure my learned friend in fact really pressed this point in his submissions, because the judge's intervention was firstly, again, a criticism of my cross-examination, and secondly, he made it clear at the bottom of page 23, that what he was doing is putting down a marker that for witnesses to tell me what a document means is really not very helpful. If I can read the document, I can work out for myself what the document means. What is helpful to know is to know whether they agree with what the document says or whether they're responsible for the document. And so that's not remotely something the judge can be criticised for. It's a fair and judicial intervention. The next example was at page 28. And it's the intervention at the bottom of the page. And my learned friend didn't give you the context of this intervention. I had been asking the question, which was an important question, and it related to the relationship between the client and the second defendant and the first defendant and how it operated. I had been asking this question since the top of page 27, and had a series of evasive answers. And it wasn't until the 6th or 7th time of asking, by the time we get to the bottom of page 28, that the judge intervened. And it was a justified intervention. My lord, the next one was at page 39 of the transcript. This is relates to a document which is at bundle H2, tab 173B, which is worth picking up here.
This is the brochure.
Exactly, my lord. Yeah. Now, it's worth just looking at the brochure.
Could you give me the tab again?
Yes, it's 173B in H2. Now we start off, it says Banker and Banker Industry Awards, but if you go over the page to page 1376, this is a brochure with Sarasin-Alpen's logo at the bottom. And if you look at every page of a document, at the bottom, at the footer, one sees the Sarasin logo. So it's a Sarasin product. And it has interviews of the bank Sarasin.
Sorry, I missed that point.
So one sees the Sarasin-Alpen logo at the bottom of page
006, yeah.
Exactly. And then at every other page going forward in the document, in the footer, you can see the Sarasin logo as well.
Yeah, that's right, yeah.
It actually says Sarasin-Alpen, but it's cut off on some of the pages. Sarasin-Alpen.
Thank you.
At page 30, at page 8 onwards.
Various directors of Bank Sarasin.
Yes, exactly. Interviews of Bank Sarasin and Sarasin-Alpen
Then we
people.
suddenly jump to Mr. Walia.
You then have Mr. Walia, another success story. And then you have, from pages 11 onwards, you have 4 pages of descriptions of their services, essentially puffing the
best private bank in the Middle East.
Exactly, even though it's not a bank, on their case.
Yeah.
And you then have 4, at the bottom of page 11, you will see the description of, this is Bank Sarasin-Alpen. Their solid capital base is underpinned by their close working relationship with majority shareholder AAA rated Rabobank. And one can see why I was cross-examining Mr. Walia in the passage we saw earlier about them puffing themselves as being backed by Rabobank.
Well, suggesting Rabobank were a majority shareholder.
Well, they were indirectly. Yes,
Of Bank Sarasin.
Of Bank Sarasin, exactly.
Yeah, but not a bank. They were not a majority shareholder of Bank Sarasin-Alpen.
No, they weren't. No, they weren't. It's another.
They weren't a shareholder at all.
No, exactly. Yeah, exactly.
But they were an indirect share.
They were indirect.
Well, indirect, yeah, because it was not a fully owned subsidiary of Bank Sarasin.
Exactly.
So that's
And page 1383, we see at the top of the page, at Bank Sarasin-Alpen ME Limited, we are dedicated to meet the needs of our clients, our comprehensive range of products and services. And at the bottom of the page, our investment professionals are always on the lookout. Our product selection is regularly expanded to keep up to date with market trends. At the same time, we can financially structure, on request, custom products to meet specific client requirements. Now,
so where's that last bit?
that's the bottom.
Oh yes, at the same
Understood.
time we can financially structure
Yes.
one request.
Which is itself quite interesting, because there was an awful lot of evidence in cross-examination from Mr. Walia saying they didn't structure and indeed couldn't structure and weren't permitted to structure. But they were saying they were structuring. But what one gets obviously from all of this is there's no doubt that this is a Sarasin-Alpen product. It's talking about what we can do, and us providing our services. That is the background to the part of the cross-examination that my learned friend went to. And one can then pick up the cross-examination, starts at the bottom of page 37, And at the bottom of page 37, I take up this document and I quote quite a lot of it. And then I say that does reflect the marketing message that Bank Sarasin was trying to put out to its customers, doesn't it? Then he says, you see, this is a marketing produced by Banker Middle East. I did not write this out. This is not how I speak. If you want to get stuck to this line, fair enough. It's a brochure put out by the organisation that you're answer. We have plenty of brochures. It doesn't mean every single line needs to be interpreted differently, but I guess it's your call. Question. It's a brochure put out by the company that you are the part owner and head of. Correct. So I get somewhere with him. Then a little bit further down the page, question, you are selling yourselves as, this is on page 39, as engaging in selling instructed, that must mean, should read structured products, to meet clients' individual requirements, aren't you? Answer, no, I think we were not selling ourselves as people who get structured products. We will listen to the client, see what his requirements are, relay them to whichever bank we think can produce the client requirement, and then relay it back to the client. And then I read the passage we've just been to. Answer, I think I don't want to debate this English too much. Really, it's a brochure. We know what we do. We know how we do it. If a brochure says we, it's not, I'm sorry. Over the page, page 40, question, it's publicised for this purpose, to tell clients what you do and how you do it, as you put it. Answer, well, enough brochures have enough mistakes, as I've seen in my 30-year career in banking, so I wouldn't get stuck on this. And then the judge intervened, saying, I thought this was Bank Sarasin-Alpen's brochure. Is that accepted or not accepted? And I say, my lord, I think it is accepted, because that's exactly what he seemed to have said at page 38, line 34. And then the witness, Mr. Walia, goes back on his acceptance, says it's a brochure produced by Bank of Middle East, which is a CPI-owned magazine in this town. And then the judge rightly picks up that it's got his Sarasin-Alpen's name on, Sarasin-Alpen's name on. Judge says, you tell me it's not Sarasin-Alpen's brochure. Witness then again says brochure produced by Bank Sarasin-Alpen for Bank of Middle East. So it is Bank Sarasin-Alpen brochure. Correct. So he's going all over the place. He's accepted it, then he's denied it, then he's accepted it. Then the judge says, are you telling me it's not true? Well, it's correct. It's a correct brochure, I'm saying. So, again, he's also all over the place. Is it correct or is it not correct? And none of the... and then one can see the judge's interventions further down on 41. And then he says that try and say they can't interview whoever they want to interview, and so on. And then over the page, the judge says, you can't tell me to forget the English, Mr. Walia. And the cross-examination goes on. And then the judge rightly says, you tell me what's in your brochure is not true, and then he says, you're putting me in an awkward spot, my lord, I'm telling you what actually, I'm not putting you in an awkward spot, and I simply ask the question, perfectly straightforward question. Are you telling me what's in the brochure is or is not true? No, it's true. So the witness is just giving completely inconsistent answers about whether it's their brochure or not their brochure, whether what's in it is true or not true. The judge is trying to get to the bottom of it against inconsistent answers, and there's nothing unfair about any of this process. But what this process does show is, like all of these examples, quite how unsatisfactory Mr. Walia was as a witness. Yes, just my learned unit just picks up one particular point at page 42. At the top of the page he had said on lines 3 and 4, we don't have the capability of structuring anything. I'd go on to add in the Dubai office. Then at page 43 at the bottom he says, no, it's true, you do not do the structuring. What I'm trying to clarify is we don't do the structuring here. We can, but we don't do it here. So it's just all over the place. He says whatever comes into his head at the time, irrespective of its truth. The next example was at page 46. That's after my learned friend, which is the judge asks him about being a banker. It starts on page 45, it goes on to 46. Again, perfectly fair questioning, because there had been an earlier answer that Sarasin-Alpen was not a bank. So nothing wrong with that. And indeed, we've just seen a brochure which suggests that Sarasin-Alpen is a bank. So the judge is quite fair to try and understand where Mr. Wilder is on this. Next example, page 55. This dealt with, I dealt with this yesterday, so I'm not going to spend any time on it, but page 55 and 56 is the reasons for not calling Mr. Nair, where the learned friend didn't, in fact, take you to the full passage, and the passage at the bottom of page 56 is important. The next example was page 59, where the learned friend says, by reference to the section at lines 14 to 19, that the judge was mocking the witness. Well, he wasn't. The judge says, Mr. Wilder, you find it possible to give evidence in English, but you don't feel you're fluent enough and competent. You have the option of giving your evidence in Hindi if you wish to do so. And assuming, in fact, that giving your evidence in English makes you feel confident in doing so. Now, this witness has already raised the point, and one can see it at page 58, lines 19 to 21. This is Bank Saracen, and my first language is also Hindi, so if you start trying to trip me up on English, then it's not very correct. And I've said it's not a question of English, it's a question of substance. That's not the first time Mr. Wilder had talked about the problem being English. Now, when a judge hears that kind of answer, it's entirely right that a judge should say to the witness that he has the option of giving evidence in the language. So it's, rather than being mocking, it's exactly the right sort of judicial intervention when a witness has suggested there's a language issue. I mean, it is right to say that Mr. Wilder's suggestion there was a language issue was completely unreal, because whatever else his problems were as a witness, language was not one of them. He was more than fluent and had no difficulty with anything. His English was perfect. The substance of what he said was a long way away from that. Next intervention was at page 110.
Page one?
Page 110 was the next criticism from my learned friend, and this was the leveraging point. And I've already been to the background to this. I'm not going to go through all the passage, but the whole passage runs from page 110 to page 113, and the short point is that Mr. Walia was being evasive, and there was no doubt about what we were talking about, and no basis for any suggestion that Mr. Walia was really on a red herring about them being leveraged of ABK. The next criticism is at page of page 146 of the transcript, and this relates to the backdated May memo, and I'm going to come to that as a topic, as part of my client's submission, so I'm not going to take time on it now. So we can go straight forward to page 167 to page 171. Now this is quite an important one. It's a passage that starts at page 166, line 17. And one needs to, this is another example where one needs to have the document, which is at bundle H1, tab 121. A, 121A, sorry, 121A. And indeed, we're going to see another example at 121B. Doesn't matter which one you look at. And what we are interested in is the filling in of the names and the dates. On the forms that were otherwise blank, apart from the post-it and from 166 to 117, sorry, like 166 line 17, I say just on the date that's also on those pages, it's quite likely the date itself is going to be unreliable because obviously it's sent out to them pre-populated with that date, and you don't know what date it's actually going to get signed. Answer, no, I think date was signed because we don't have a typewriter in our office. We've never had one, so this date was probably typed in by them. And the judge then makes the obvious intervention about typewriters and word processors. The idea that this is a typewriter production rather than simply pre-population of a form on a word processor was somewhat absurd. And Mr. Walia's suggestion is that the forms at tab 121 were just sent out without anything on them at all and just post-its, and that the clients filled in blank forms. Now, it is interesting to note that there are other documents in the bundle where Sarasin-Alpen populate their own documents, boxes in their own documents, in exactly the same way with their word processor and with the same type font. You can see an example, for instance, at 128. It's one of the confirmations of investments.
I mean, that suggests it's in electronic form.
Of course. I mean,
and going back to 121, I don't understand the suggestion that a typewriter was used to fill in the title or name of the client, or for that matter, and presumably a different typewriter and or word processor to type in the date on page 50008. I mean, was there any evidence as in what format these documents were sent to the client?
no.
The impression I had, and maybe it is solely an impression, that on the face of it, the document was sent with a name, otherwise the recipient wouldn't know it was directed to him, which may have been misspelled, and that somebody had put into an electronic version of these business conditions a misspelled version of Mr. Khorafi's name, and that was the only insertion in the whole document, which was then sent electronic to Mr. Khorafi's office, and he then, or his secretary, then filled in the date, Kuwait, and then it was printed off and he signed it. That's the impression I had.
Well, that impression is right in some parts. What's wrong about it is that it wasn't sent electronically. It was unchallenged that this was couriered to them.
No,
so what they got was a hard copy.
Right.
What the learned friends would have expected them to have taken their own hard copies, but we never got anything on disclosure of what was sent from them. What we got was this version, it was on our code.
Version of 121 is disclosed by who?
But we disclosed,
Right.
because we had it. My Lord may remember that when this case started off, what was said by Mr. Brindle's client's former solicitors was that the filled in...
Yes, I understand all that. I'm not sure we need to spend too much time on this.
No.
Well, all you're on is whether there was any unfair intervention
I know.
in the evidence in relation to the use of a typewriter and so on. I'm not sure the Lordship's his observations, the judge's observations, don't seem to be anything other than pretty mundane. But
Well, that's exactly right. And of course, it's another area where Mr. Walia was being absurd, because we've seen that Sarasin-Alpen is capable of pre-populating its documents, because it does so elsewhere. The idea that one needed a typewriter, which they didn't have, to fill in the date and the name was absurd. And the
it's slightly puzzling that the date and face of signature is on this document.
Well, that was
if it wasn't in electronic form when it was received, I'm not quite sure how that works.
Because what happens is they know they're sending it to Kuwait, our case, in my submission, there was no real answer to it, was that Mr. Nair pre-populated the document.
Okay.
He put in the name and the place.
Well, certainly if it was in hard copy, it's difficult to see how anybody could have typed that in.
The whole thing's absurd.
Yeah.
What they got was these documents pre-populated with post-it notes saying sign here, effectively. And then they signed.
The only difficulty with that is that it came common ground is that these were sent on the 24th of April. So what the learned friend is posturing is that Mr. Nair pre-populated it with the date of the 6th of June, because they were sent to them on the 24th of April, which is the point
They were.
I was making.
That was not common ground, and it's not correct. They were not
No, right.
Those are the
I agree, if it was
Just
common
remind
ground,
the
it is another oddity.
It would be an oddity if it were common ground,
Yeah.
but it's not common ground. Those were not sent. In fact,
Certainly they're pleading.
it was one of our many criticisms that these were not sent out until quite late in the piece. So anyway, that's that point. But my lord is right. What one is on, what matters about learned friend submission, but there's some unfair intervention here. And again, the cross-examination, in fact, goes on for a few pages, and we don't need to go into the detail of it. The intervention is at 174. Well, the intervention. Where does the intervention come? 168.
So, where?
The intervention's at 168.
Yeah.
Then the judge makes the correct point that if the witness's suggestion is that these forms were completely blank when sent out, that should have been put to our witnesses, which it never was. And so that's a completely fair observation. Cross-examination then goes on for a few pages, and at page 174 to 175, the judge rightly raises with Mr. Brindle the fact that he hadn't challenged our witnesses on the proposition that this was a blank form, and he's given the invitation to do so.
Actually, he's putting the proposition that there wasn't a challenge to Mr. Khorafi's statement.
Exactly.
That they were sent to him on the 6th of June.
Exactly.
Slightly different.
Sorry, I'm sorry, yes. I may have jumped ahead of myself.
Your Lordship would have
And
noted
then
the point at the
Mr.
top
Brindle
that
comes back to that
about the
point
pleadings.
later on the same
the
page.
reference says it's not accepted, but he never amended the pleading. The pleading always said that those documents were sent on the 24th of April. That's the point I make at the top of 174.
Well, the learned friend had
Well, maybe, but in the end, the judge has got to make a finding of
yes.
real fact
It-
and real life, rather than necessarily depend upon what's in the pleadings.
And that's why, that's exactly right, my lord, and that is why the judge says, now that this point's arisen, is it part of Mr. Brindle's case? That's what he says at bottom 175. If it's going to be suggested Mr. Khorafi typed in his name and the date, then I think you really must. Mr. Brindle, I appreciate that, my lord. I haven't risen to deal with that point, and I've heard what's said about it. Question, is it part of your case? Mr. Brindle, I'm not aware. It certainly wasn't. I didn't put it, and I didn't intend to put it. I have no intention of putting that point. That was not something I forgot to put. So it is left on the basis that Mr. Brindle, it is not part of Mr. Brindle's case, and it's not going to be part of Mr. Brindle's case, that Mr. Walia's version of events is correct. Again, nothing to criticise the judge about on any of this, but another example of unsatisfactory evidence from Mr. Walia. The next example is at page 178 of this transcript, and this is again dealing with this same form. The passage starts at page 9, 6 to 7, page 178. No indication needs to be filled in either, no post-it notes, for instance. This was talking about the important parts of the form that were not filled in, which there were no post-it notes inviting them to fill those in. Answer, correct. They were supposed to be filled up by us or the client. They were not. So we called the client. We had met the client a number of times with him, got the information and filled it up ourselves. So Mr. Walia positively asserts that we called the client. That might be deemed explanation 1 from Mr. Walia. One then goes forward to page 184, line 20 to 22. I mean, there's obviously a lot of questions in between, but we're all still on this topic. Answer from Mr. Wiley, line 2020-22. The information was filled in by Mr. Sarasin-Alpen on what he heard from the financial advisor, either on the first or the second meeting. So that might be called explanation 2. At page 186, His Lordship, the answer, they present the picture which was Mr. Nair was Taha. His Lordship, did you ask Mr. Nair about that? Actually, did you ask Mr. Nair about that? Did you ask Mr. Nair when he spoke to Mr. Taha? No, I did not. Answer. How are you able to give the answer you've just given? The information which in the form was also, did Mr. Nair tell you that? Did Mr. Nair tell you that? He did when he came back. After he came back from the first meeting. After he came back from the first meeting, correct. These were, again, differing explanations from Mr. Walia, and another example of him making things up on the spot. One then gets to page 187. His Lordship, you told me just now that this information was filled up as a result of a telephone conversation after 6th of June. That, of course, is a reference back to the passage I started on at page 176. Page 178, line 67. So, which answer, if either, am I to believe? And then we get the answer, sir, is we had the first 2 meetings, I was the second meeting, I heard the information, the forms came back to us blank. Presumably, I presume that Mr. Nair would have called and said, why haven't you filled up these forms? And we will do that for a client. So having initially said we did call, Mr. Nair made this call, it turns out to be a piece of invention or speculation. His Lordship, you told me that he had called the client to obtain the information from the client. I think you'll now tell me you don't know that, so you'll give me another explanation. Why should I believe a new explanation any more than I should believe the last one? I'm sorry, my Lord, maybe I got confused. I don't think you got confused at all, Mr. Wiley. I think what happened is you realised you'd got trapped. Now, well, one could hardly have a more accurate characterisation of what has just happened in the previous pages of transcript. Now, my learned friend characterised this as saying Mr. Wiley just said something and didn't pursue it. Now, it's not a question of pursuing things. This isn't legal argument. This is evidence on oath about what factually happened. And it's just a demonstration of Mr. Wiley's total unreliability. Now, the next one raised by my learned friend was at page 194, but I think my learned friend's submission was actually a fair intervention, so I'm not going to take time on that. We then go to day 6, and page, which is at tab 56, and page 9 to 16 is the passage with the intervention at page 15. I'm not going to go to the detail of that one because I think that's quite a minor example, but in my submission the intervention was entirely fair and justified. The next one is at page 139 of this transcript.
129.
139.
Thank you.
And this is one of the ones from my learned friend Skeleton. Now this, I did say earlier that there was one exception in terms of the relevance of any of this to the key findings by the judge, and this is the exception because it is actually relevant to their ground 1.1. And it's a passage that starts at page 139. And what this passage was about was I was cross-examining in respect of one of
This relates to the change in the underlying investment.
Exactly. I was one of a second wave of term sheets. And this was a deal done in July, where the final term sheet didn't come out till October. And when it did come out, it transpired the clients had not been given the underlying equities that were signed up for. And again, it is worth seeing the documents, which are at bundle H2, tab 152. And you need to have sort of one finger in that and one finger in tab 155. So at 152, one sees on at page 6498 the basket that's signed up for. And it's worth, my lords, marking, just to save a detailed exercise later, in that basket I'm just going to identify the ones that are not in fact given. Natural gas, 40%, doesn't get given.
So what doesn't get in?
The natural gas, 40%, they don't get. The Cornu Cop, whatever that says, Corno Cop, they don't get. Schlumberger, they don't get. Further down, Halliburton, they don't get. PetroChina, they don't get. Tenaris, they don't get. Australian Worldwide, they don't get. You then see tab 55, which shows what they do get. They don't get all the stocks I've just identified, including 40% natural gas. They do get the first. I'm looking at the last page.
6513.
Exactly right.
Yeah.
Yes. So that's what they do get. They don't know this till October. So this is several months after the deal is done.
Is this 40%? I can't work this out. Maybe it is.
So again, just to let you know, they haven't got all the ones I've just identified.
No, I see that.
And what they have got, additionally, which they didn't ask for, is the bottom two, Iberdrola and Tokyo Electric Power.
Thank you.
But then Julia reminds me that I said they received this in October. There's in fact no evidence they did receive this in October. No evidence they ever received these term sheets at all. But the earliest that they could ever have received them would have been October.
Well, maybe, I don't, of course, I don't have the precise date of purchase, but it may be one of the terms of the derivative that the issuer can change the underlying security. I don't know.
I don't think that works, my lord, because it's not a packaged, traded, normal derivative. It's a bespoke product.
Yeah.
So you just wrap up the equities, buy the equities, and sell the product. It's not as if you're going on getting an off-the-shelf one and the issuers have changed it. So, my lord, that was pretty startling, and that's why I went through the went through this with Mr. Walia, and the cross-examination had in fact run from pages 133 of the transcript through to 139. So I start at bottom of page 132, back on D4 energy basket. See what was being asked for was natural gas, 40% weighting. Do you see that? And then I explained the point. Answer on line 11, 133. There are some common stocks, but yes, it's different. Question: some common stocks, and so on. Answer: correct. Again, the client has not even been given what he's signed up for. Answer: yes, that's correct. Question: how does that come to be? Answer: because, like I said, when we do a draft term sheet, that is what is looked at. When financial engineering actually goes to execute, at a point in time, they cannot get the right pricing for the right stock, and they would go ahead and in the approximate area of the type of companies they want to invest, they would go ahead and do it. Question: you would need, if there are material differences of this kind, to go back to the client, wouldn't you? Answer: correct, but this always happens as a matter of practice after the trade is done, not specifically on this client. Question: how does that work to go back after the trade is done? Because the trade is done by that point. Correct, the trade is done. Question: it's no good to go back as a matter of practice after the trade is done because the client is not getting what it signed up for. Answer: I agree. But if the client objects after the trade is done, like I said, this is standard operating procedure. The client gets what has been done. If he doesn't like it, you have to unwind the trades. Question: how's the client going to know? Answer: when he gets the term sheets. This client doesn't get the term sheets until after October 2007. If you see what's out here, the first term sheet was signed up for, it says indicative term sheet. Trade gets done as of October, as I can see out here, and it shows there have been some adjustments in October as of October 2008. Question: that's not right, because we were looking at the bank statement, the trade is done in July. The term sheet isn't delivered until after October, and that shows an adjustment at October. There is a technical point, is there is a minor point about adjustment for pricing between July and October, but that's nothing to do with the substantive point I'm dealing with. Answer, I wouldn't know. It's difficult for me to comment on this. And then question, you see the nature of the adjustment. So the October adjustment, as you'll see from the footnotes, is itself very minor. We don't need to worry about that, correct? It's not the October adjustment that matters. What matters is the whole trade, which is put on in July, which is totally different from the thing the client signed up for. Answer, like I said, it's not totally different. For at least 4 of the stocks, from what I can see, are common. 4 are different. Question, weighting's completely different. There's no 40% natural gas component at all. Answer, correct. Client doesn't know about this until after October, correct. Contrary to your suggestion that the client, if it objected, could object quickly, the client can't object for many months, I agree. Client doesn't get to know for how many months that it has an unrated issuer, even though the issuer risk is one of the principal risks of the product. No, I think the client knows this because, like I said, the bank Sarasin statement goes in every month. It shows who the issuer is. Question, but doesn't say what the rating is. Answer, it doesn't say no. You're expecting the client of itself to know about the rating of the issuer, are you? Client knows that Bank Sarasin is not rated. Bottom line, and that's just a point, just to note, Bank Sarasin is not rated. My learned friend made a great play about what a great institution it was. It was not a rated institution. Question, bottom line is that the client, Mrs. Hamad in this case, did not remotely get what she even signed up for. No, it's fairly similar. I don't think the word remote is correct. Now that's an important answer, because it does shows Mr. Wiley didn't seem to really care. And then you get the judge's intervention, and then Mr. Walia, over the rest of page 137 and 138, tries to say, well, it's all right because they wanted 40% natural gas. And just when one, it's important to know that when it says natural gas, that actually has on page 6498 of tab 152, that actually had a Bloomberg reference. So it wasn't some sort of generic description. It was a product with its own Bloomberg code. And so you couldn't possibly say, well, they got some stocks in some companies that might do a bit of natural gas. And which is what Mr. Walia was trying to say in paragraph 138. I then, Mr. Walia then says, answer 15, no, it's not acceptable, we have to give the client what they asked for. If I look at 12.5% weighting for given Exxon, Chevron and Royal Dutch, that already goes to 37%. I'm sure one of the other companies would have, but it's 37, 38%, maybe not 40% weighting natural gas. So he's not saying, my lord, this is terrible, we sold the wrong thing, I don't know how it happened, I'm going to go and make inquiries. He's saying, oh, it's all right, because with these other stocks, you sort of get 40% natural gas, sort of. To which the judge rightly says, you're sure the other companies would have. Why are you sure about that? Answer, because some of the judge, have you asked anybody? No, I did not ask. How can you be sure if you haven't asked anybody? No, I did not ask. And then the judge said, does your company still have a license in the DFSA? Rightly so. This managing director of this company that calls itself a bank and markets products doesn't seem to care that clients are sold a product that's different from the one they've signed up to. And that's why the judge says this is how it carries on business, and you regard it as acceptable, because that's the point. The witness had been saying it was acceptable. And then in the next part of the transcript...
Well, it throws some shadow over the financial engineering at the second defendant's office.
That too. That too. And that's why in the next part of the transcript, I then say, pick him up on this idea of it all adding up to 40%, because the stocks he was adding up to 40% were the same stocks as they were going to get anyway. So it just didn't work. And that's why the judge then says this other point about 40% answer, we give him 37.5%, 3.5% less. So, sorry, there's a bit when I say the arithmetic doesn't work. And then at the top of the next page, the judge says the arithmetic doesn't work, but I don't think Mr. Wardia is terribly concerned about that. Well, absolutely